Can I please speak with Mr. Schuler, please?
This is he.
This is Deputy Stockman. How can I help you today?
Yes, I appreciate you calling back. And you might remember we talked last Saturday. You came and took the incident report on the assault. And just I've got a copy of the report, and just wondered if I could check with you on a couple of things. It's listed as assault. I'm sorry, can you hear me?
Yes.
It's listed as assault 3rd degree, and I just wondered who made that determination.
That's the Code of Alabama made that determination. That's the way it's written up. Anytime there's any kind of injury or anything like that. I'm sorry? I said the Code of Alabama has determinations on that on the varying degrees of assault.
But, I mean, you're the one that wrote it on the report, I presume? I mean...
Yes.
Okay. Well, what I was concerned about is I've read the Code of Alabama, and it clearly is not 3rd degree assault. It's clearly 2nd degree, and I just wanted to understand. I just don't understand how it was listed as 3rd degree. I mean, you might want to get it there in front. I mean, it's hard for you. I know you don't have it in front of you, but...
Oh, that's what I do.
Well, okay. I mean, I'm looking right now at Section 13A-6-21 and subsection 2, or item number 2.
Okay.
And it seems to me that number 2 under 13 under section dash 21 seems to be the controlling authority here.
Okay. Did you look up the definitions to a deadly weapon or dangerous instrument?
Yes.
Okay.
I did.
You also have to have intent to cause serious physical injury, and you have to cause serious physical injury.
No. Do you have it there in front of you? Read number 2.
I'm looking at it.
It says with intent to cause physical injury. Doesn't say serious. That's what 1st degree says. With intent to cause physical injury.
Have you been and spoke with a magistrate?
Yes, I have.
What did they say?
Well, they went with what you had on the report. They haven't been there. They haven't looked at my back. They don't know anything about it.
Okay, well, if that's what they went with, that's what they went with. They can move them.
Well, they haven't gone with anything. I haven't signed anything. I'm just asking you.
If you want to talk to the authority on it, you can talk to the district attorney's office, because they're the ones who would be prosecuting the case.
Well, I have talked with them, and they referred me back to your office, so I'm kind of getting the runaround.
I mean, they're the ones who prosecuted, okay?
Well, I'm just asking you, since you're the one that put on the report that it's 3rd degree, what you based it on. That's all I'm asking.
The fact that it was just a scrape.
Well, it's not a scrape. You call it an abrasion.
Okay.
And I can read to you case law that says that, and it was bleeding, a bleeding abrasion. I've got case law here that says someone being kicked in the shins is physical injury. Someone with a split lip, somebody with the skin on their nose, all those are physical injury.
Okay.
And an abrasion on my back, a bloody welt, which would have been far worse if I hadn't been wearing a sweatshirt, is physical. And even I talked with Bill Bostic yesterday, and he admitted, he said it's a very low threshold for physical injury. That it was bleeding, it was sore. So you're saying that...
Mr. Schuler, what I'm basing this off of is my experience in the law enforcement field, okay? This isn't the first assault I've worked with. I've been assaulted.
No, I'm sure you have.
Much worse than that. And was lucky to get assault 3rd. And that was an assault on a police officer while resisting arrest.
Well, I don't know the circumstances of that case. I know the circumstances of my case. Okay. And I know what it says here. And it says a deadly weapon or a dangerous instrument. Now, it's not a deadly weapon. I'm the first to say that sign's not a deadly weapon. But the law says a dangerous instrument can be anything as small as a pencil, depending on how it's used. Well, this guy took...
I can keep telling you what I'm telling you, and I can keep telling you what's on the report. I mean, the only thing I can do past this is, advise you to speak with my supervisor, if that's what you'd like.
Well, yeah, I mean, I just wanted to be correct. I want the law applied to my case like it is to everybody else's. That's all I'm asking.
That's where I get back to. I pointed out my experience working these kinds of cases, including stuff that's involved me.
Well, what has happened to you on other cases? What I want applied is how the law is written.
Okay.
And I can read it right here. And that sign, a pencil that is thrown at somebody can be a danger. That's what the law says.
Mm-hmm.
And a sign that is swung like a baseball bat with both hands by a grown man. I've got a case here in front of me, Berger versus State, that says a woman that kicked a man in the shins. A woman kicked a man in the shins was called physical injury enough to warrant second degree.
Okay.
And this is not even.
That's what I put on the report.
I understand. And then you were.
And I can tell you're obviously not going to be satisfied until it's either changed or someone else tells you. That's the reason I'd like to go ahead and just recommend that you get in touch with my supervisor. I can give you his name.
Okay.
Okay, it's going to be Sergeant Moore.
I will say this: I'm very pleased with the way you handled it. I very much appreciate you getting and talking to the witness. I've talked to her, and
that's what I based it off of. Was because when I have two people that have two varying different accounts of what happened, which is exactly what I had with y'all. You're going to have your side of the story. He's going to have his side of the story. All I really had to go on of an unbiased opinion was somebody that happened to be driving by.
yeah.
I mean, that's another part of why, way it was written up. I mean,
Well, and her unbiased opinion was, according to your report here, she stated she saw Mr. McGarity hit Mr. Schuler as he was walking away.
mm-hmm.
So he clearly hit me in the back. Everybody agrees he hit me in the back. So what's, that's intent. And I asked her, I don't know if you asked her this, I said, did you see me? He's claiming I hit him first, and she said, I didn't see you with anything. And I said, that's because that's the way it was. He's claiming I hit him with a sign. There was only one sign that there may have been one laying on the ground. I never touched the sign.
Mm-hmm.
I don't know if he's claiming I hit him, then I handed him the sign and said, here, you hit me. And you've been assaulted, and just think of just common sense here. If I had hit him first, I'm going to probably do one of two things. I'm going to hit him again, or I'm going to turn and run. I'm not going to just walk away slowly, as this woman said, and as I said, and as even he says. He hit me in the back.
Mm-hmm.
And the thing is, he needs to file an assault charge if he claims I assaulted him, and he hasn't evidently.
Well, see, I can't make people file their own, file reports. I can't do it. If you're filing a report, dadgummit. I mean, people have to want to do that.
Right.
I mean, and
well,
don't think in the time I was talking with him, and when he claimed that, I was like, well, would you like to file a report? And he said no.
Well, yeah, he said no because he's lying his ass off, and as you and I talk to people, lie to you all the time. And I feel for you having to go through that, but it's like mine's being downgraded because he lied to you, and he lies all the time. He's got a criminal record. Why isn't that not taken into the equation?
Because it's just like you said. It's like you don't know the specifics of my case. Those other cases he has against him don't apply.
Well, you're right. You're right. And the thing I'm asking though is I just want this. For one thing, I have 2 points. Number one, I believe it is second degree, but beside that, it clearly is not third degree. There's nothing. If you read third degree, there's nothing in there that applies. The only one, if you've got -22 in front of you there, number 3 is the only one that mentions a dangerous instrument. And it says with criminal negligence. Well, that didn't involve criminal negligence. He wasn't swinging the sign around and I happened to walk into it and, accidentally. He hit a specific person for a specific reason. That's criminal intent, not negligence. So not only...
Another thing I can compare this to, Mr. Schuler, is the domestic violence cases that we run into. And domestic violence falls under the assault protocols as well, is the fact when a man that's much larger than a woman hits her, or hits her with something, a phone cord, a lamp, a beer bottle, and you have injuries similar to that. I mean, those always go through as assault third also.
Well, again, you're talking cases that don't apply. I've got one right here that I can tell you. It was in Shelby County just a few years ago where a woman kicked a man in the shins, and it was determined to be physical injury second degree.
Well, you know.
I'm sitting here reading it.
I don't have the specifics of that, and even if I did, I'm not the judge who ruled on it. You know,
well, I'm not talking about the judge. I'm talking that's what it was filed as.
See, I do not prosecute these cases. That's the reason I said you have your remedy with the DA's office. I mean, if they won't talk to you on the phone, you need to go down there and talk to them. Well,
I talked with Bill Bostic yesterday, but mainly I just wanted to, I don't know who determines the third degree. Evidently you did, and that's fine. I disagree with, with your determination. You've given me the name of the person I need to call, but I just want the law applied the way it's written. And I'm sitting here at the point where I'm afraid to walk in my neighborhood anymore. And I just want people, and I think the fact that he's a white guy who lives in a nice house shouldn't be any different from some poor woman who lives out in the woods. She got hit with second degree. And anyway, but I mean, the best. But you're telling me evidently from what you said that you determined I didn't have serious physical injury, which I agree. It wasn't serious, but it is physical injury, and under Section 21, subsection 2, under assault second degree, if you cause physical injury to another person, not serious but physical, with means of a dangerous instrument, that's second degree. And that's, and you can read it, I can read it.
All I can tell you is to, carry your argument up to my supervisor.
Okay. Well, is his number the same as yours, I guess?